What is a plea bargain? A plea bargain is an agreement between you and the prosecutor on a punishment you will take in order to end your case. Although you have reached an agreement with the government, the judge still needs to approve that agreement. Plea bargains or plea agreements are very common. It could be a felony plea bargain or a misdemeanor plea bargain, depending on the charges against you. They are the alternatives to taking your case to trial. A plea bargain example would be that you agree to plead guilty and accept 1 year of probation. Should I take a plea bargain? There are advantages of plea bargaining and there are problems with plea bargaining. A common problem is taking a plea when you're innocent. Many people say, "I would never admit to something I didn't do," and that makes sense, unless you're facing a trial. Sometimes when you consider the evidence the Commonwealth could introduce at trial, it's a smart decision to take a plea deal. For example, perhaps there's a witness in your case that will testify that he or she is 100% sure that you are the one that committed the crime. You may not have any evidence, such as an alibi, to dispute that witness's claim. Advantages of plea bargaining include having some control over the outcome of your case. The plea bargaining process is a negotiation. You don't need to accept what the prosecution is offering you. You always have the right to take your case to trial if the government's offer is no good. As part of the process, you may be able to have some of your charges dismissed. This is especially helpful if you can plea out to a misdemeanor rather than a felony. If you are found guilty of a felony after trial, you are forever a convicted felon. That is something that will follow you for the rest of your life. The types of plea bargains there are can be categorized by the sentence you receive after the plea bargain and the plea itself. There are many possible outcomes to your case. They can be looked at from best to worst as follows: dismissal, filed without a change of plea, pretrial probation, a quaff, guilty probation, guilty with a suspended sentence, and guilty with jail time. Having your case dismissed is the best possible outcome. Dismissals by the Commonwealth before the day of trial are rare. The district attorney's office must decide that they are unwilling or unable to prosecute your case. Where we typically see dismissals on the day your case is scheduled for trial. The most common scenario is when the only evidence the Commonwealth has against you would be the testimony of one witness. That witness is summoned to be into court. If that person does not show up, the government cannot go forward with their case. Therefore, we would ask for a dismissal. Another way your case can get dismissed at trial is if a witness has a privilege. A privilege is a rule of evidence that prevents someone from giving information about your case. The spousal privilege is an example. In that case, if you are legally married, your spouse can't be forced to testify against you. In a Fifth Amendment privilege situation, the witness can't be forced to testify if their testimony would expose them to criminal liability. At your arraignment, a not guilty plea was entered on your behalf. If your case is filed without a change of plea, it remains open for a period of time. At no time do you admit to any wrongdoing. As the name suggests, you are not changing your plea from the not guilty. Basically, your case goes into a file for a period of time, let's say 1 year. If you don't get rearrested during that year, the case gets dismissed. Pretrial probation. Pretrial probation is similar to a filing without a change of plea. In both cases, you don't admit to any facts. In a pretrial probation case, you will be placed on probation for a period of time. You'll have to pay a $50 per month probation supervision fee. The judge can also include conditions of probation. Typical conditions of probation are to attend certain classes or to perform some community service. Continuation without a finding of guilt. There are two big advantages to a continuation without a finding of guilt, also referred to as a quaff. The first big advantage is that it is not a conviction. You are not pleading guilty to the charges. Rather, you're admitting to sufficient facts. Basically, you're saying, "I'm not guilty, but I don't want to take my chances at trial." The second major advantage of a quaff is that you can have the charge ultimately dismissed. With a quaff, you will be placed on probation. If you successfully complete your probation, your case will be dismissed. Generally, quaffs are available to first-time offenders, although there are certain exceptions. Your criminal case in Massachusetts may also result in a guilty with probation. A guilty probation is one step worse than a quaff. In a guilty probation, it is a conviction. If your charge is a felony, you are now a convicted felon. That designation will follow you for the rest of your life, causing significant problems. Even a conviction on a misdemeanor can cause you trouble. The advantage to accepting a guilty probation is that you don't go to jail. But there are long-term consequences as well. A conviction, especially on a felony charge, can prevent you from getting certain jobs. It can keep you out of some places to live, and it can prevent you from entering the military. Guilty with a suspended sentence. After guilty probation comes guilty with a suspended sentence. This disposition has all the downsides of a guilty probation with one significant addition. What happens is, at the time of sentencing, the judge sentences you to committed time in jail or prison, but the judge suspends that time while it hangs over your head for a period of probation. If you get rearrested or otherwise violate your probation officer will have you brought into court as a potential probation violator. If the judge hearing your case wants to sentence you to any jail time whatsoever, they must impose the full length of the suspended time. The worst outcome of all is that you are found guilty and sentenced to a term of incarceration. As harsh as this outcome is, you may still want to consider it depending on your case. Sometimes the amount of jail time you're accepting is much less than you would expect if you took your case to trial and lost. Sometimes you are allowed to accept a committed sentence on a misdemeanor, but will receive a quaff on a felony charge. This would save you from being a convicted felon. A plea bargain or a plea agreement is incredibly important. Most criminal cases are resolved by way of plea. As you can see, there are many possible outcomes, all with serious consequences. You must first decide whether you want to plea at all. The advantage of a plea bargain is that you have some control over the outcome. The alternative is to take your case to trial. At trial, you're letting a judge or a jury decide your fate. You should seek the advice of an experienced criminal attorney before making